Hello, welcome to Legalese. Legalese is a legal information program put on by the Northern Middlesex Bar Association. It is designed to give an overview of some topics within the law, within the court system, that may be of interest to some of our viewers. It is half an hour in length, and it's, as I said, designed to give a general overview and is not designed to be legal advice. Today I am joined by Judge Elizabeth Cremins, who is now the newly appointed judge of the Air District Court. Judge Cremins has been appointed as of this summer in light of Judge Kilmartin's recent retirement. And I welcome you, Judge Cremins. Thank you for coming.
Thank you very much. It's my pleasure to be here. I'd also like to take this opportunity to thank the Northern Middlesex Bar for welcoming me so nicely to the Air District Court and being so helpful to my getting oriented. So it's a pleasure to be here.
Well, it's a pleasure to have you, and I thank you again for coming and helping us with this program. What we are talking about today's topic is dispute resolution. That's the topic. The title of the show, and the topic deals with issues of alternative dispute resolution, but also how that alternative dispute resolution plays out in the trial court system. So this phenomenon of alternative dispute resolution frequently takes the form of arbitration, mediation, conciliation. These are terms that I think are understood within the public arena, but maybe need to be defined a little bit. Judge Cremins, perhaps you could define for us what the arbitration and mediation are.
Well, I'll give you a brief definition of them. I think they oftentimes intertwine, but arbitration usually means there's binding and in non-binding arbitration. And what the parties do is they have a neutral arbitrator. When I say neutral, that's somebody who has no involvement with any of the parties before that person. And it's usually somebody trained in the area of the law that they're arbitrating. And that person listens to both sides, sort of like a trial. Evidence is presented. Sometimes there are what we call relaxed rules of evidence, things that might not be able to be introduced at a trial because of rules of evidence. The parties agree can be heard by the arbitrator. And then that person renders a decision. And sometimes it can be more than one arbitrator. It depends on how it's set up.
So an arbitration is very much like a trial might be.
I would say so, yes.
And how might it be different from a trial?
Well, as I say, sometimes the evidence that can be introduced is more relaxed. In addition, the parties may also have set certain rules about the choice of the arbitrator. Arbitration goes way back in our history. I think oftentimes people think of it in labor disputes, which oftentimes don't ever get to the courts, but the labor contracts mandate that there be arbitration over disputes that arise in interpreting the contract.
And in fact, a lot of contracts contain within them requirements that one arbitrates rather than seeking a trial by jury.
Exactly. I think a good example of that is sometimes in contracts between companies, and these are in the business context. I would never recommend that a citizen enter into a contract without some experience and say that any dispute will be resolved by, in that case, probably binding arbitration. But oftentimes in contracts between companies, if they mandate as a condition of the contract that if there is a dispute, that they will use arbitration. And there's the American Association of Arbitration that's been around for many, many years. However, with the recent, shall I say, increase in alternative dispute resolutions, there are a lot of other companies. But typically the American Arbitration Association is the most recognized one for arbitration in the context of it being a part of a contract.
Now, the role of arbitration now is primarily, as you're indicating, a private one. Is there a move now toward more of a public sector with the courts?
Well, sometimes you'll find a case may be filed in court, and as it goes on, the parties, the litigants determine we need to get to resolution. And the court system is such that it's taking too much time, and they may themselves agree to arbitrate it and then take it out of the court And then, as part of that, though, I would say if there is arbitration and the party who, shall we say, doesn't get the favorable decision, doesn't follow it, the court then becomes available to enforce the arbitration.
Sure.
And we have a special cause of action, which is to enforce arbitration. And again, but that's how it would develop in the court system in that way. Typically, our alternative dispute resolution programs in the court aren't arbitration binding or non-binding. They usually are more in the context of mediation and conciliation.
Well, let's talk about mediation first, and then maybe the
Well,
difference with conciliation.
I'll give you some general idea. Mediation is where you have, again, a neutral. And I want to be very clear. In Massachusetts, we have rules that apply to, that the public should be aware of, for making sure mediators are trained and knowledgeable on how to conduct their business. So if somebody wants to mediate something, please consider being sure that that mediator is trained. But the mediator is a neutral, and it doesn't have to be a lawyer. And that person sits down with the parties and really tries to get them to yes. And they really try to guide them to yes. And they use various techniques to do that. And when I say techniques, sometimes it's listening to both sides together, then listening to one side, the other side, then talking to each side. But the whole focus is to try and get them to reach an agreement that's satisfactory to both sides, again, usually with compromise.
Sure. Now, mediation frequently takes place, again, outside of the court, where you have mediation services, and obviously that needs to be done by a trained professional as far as the mediation. You brought up the term neutral. Mm-hmm. What is the significance of a neutral person, and how does that person play?
Well, a neutral is a person, it's a term we use in our rules of training arbitrators, mediators, or conciliators, that they have no, shall we say, dog in the fight.
Sure.
They don't know any of the parties, and they have no predisposition that they're aware of. If they do, they then absent themselves and don't get involved in them.
And that's designed to ensure impartiality,
and fairness, yes.
no conflict of interest,
Yeah.
and fairness. You want to have you want to make sure that that person
Yeah.
has no dog in the fight, so to speak. So the differences between well, let's talk about mediation in terms of some of the mechanisms as to how that may play out.
Let's see, I give you a great example. As I said, I'm very happy to be in Air District Court. And as I've found out, we have wonderful professional individuals in our clerk's office, in our probation, and our maintenance, and our court officers. But one particular example might be the clerk magistrate, Wendy Wilton. Mm-hmm. I would say she's a pioneer in using mediation and introducing it. She does it in the context of small claims. Now, small claims is supposed to be very accessible as it is.
Yeah.
Anybody can file it. You don't need a lawyer. But when we have a small claims session, Magistrate Wilton has involved mediators to be there, just to help, because oftentimes the parties are unrepresented, and it gives the parties an opportunity, if you will, a dry run before they present their case to the magistrate,
Mm-hmm.
chance to talk to somebody who maybe can help them out and hear their side. And actually, the Middlesex Community College Law Center has a major program in mediation, arbitration, and training neutrals. And it's through that program that volunteers come and serve as mediators on Thursdays when we have small claims, if it looks as if they will be needed.
Now, one of the hallmarks of these alternative dispute resolutions is, well, in this case anyway, mediation, would be voluntariness.
Exactly. Totally voluntary for the parties. I want to be very clear. Any program involved in the court, it's voluntary. Now, again, as we talked at the beginning, oftentimes people enter into contracts or labor
Sure.
disputes where it becomes mandatory that they have to
Sure.
arbitrate a dispute. When you come to the courts in the Commonwealth of Massachusetts, nobody forces you to mediate, conciliate.
Now-
And so,
Good.
yeah.
I'm sorry.
But I'd like to talk about that, because part of this is we do have volunteers, not only lawyers and citizens who are trained as mediators. And I want to say at this point, I am so impressed with the commitment that attorneys have made to alternative dispute resolution in Massachusetts, which essentially they do pro bono. And our state is not a mandatory pro bono state for attorneys. You know, some states you have to do 50 hours of pro bono work per year. So we are having attorneys that see the importance of this and are giving their time to these programs.
And I've found that these programs are tremendous asset as far as pushing along a case for settlement or for honing some of the issues. The Superior Court now has in place a conciliators
Yes.
program. And maybe that's a good time now to talk about conciliation versus mediation. They're somewhat similar, but there are some significant differences.
Conciliation usually, in that case, you would bring somebody who's experienced, who knows, shall we say, as by the way, anybody who's trained as a neutral to mediate in a situation in the court is trained in the law that applies to the particular situation. They're not, however, they don't practice law if they're not lawyer. They're just,
Right.
But you know generally what the issues are so that you can direct the mediation appropriately. Conciliation, you use an attorney, someone who's got some experience with the law.
In all cases, the conciliator is an attorney.
For the court. Now,
Yes.
you could, again, privately, you can create your own kind
Sure.
of conciliation you want by whatever, but in the court programs, we use attorneys. And they have to have 3 years of experience as attorneys, practicing attorneys. And they then meet with the parties, and usually at the time in which the discovery, and when I say discovery, the people have exchanged the information on all sides regarding the dispute. And they sit down and talk to both parties and see if they can, two things, get them to settle, reach an agreement, or if not that, talk about what the issues of dispute are. And so it really serves two purposes. Sometimes it does get settlements, and people leave a lot happier than if it were a judge or a jury imposing a settlement because they're part of it.
Sure.
And the other thing I think that happens is the conciliators can help the attorneys if the people are represented or if they're pro se, or even if they're represented, but they hear it from another person about what that person, the conciliator who's got some experience, sees the issues to be. And then if it doesn't settle, it comes back to the judge to get set down for trial. And by the way, everything that's said in these things is confidential unless the parties want it to be discussed with anyone. So those are some of the rules of mediation and conciliation, that it's confidential what you say to the conciliator or the mediator. But then when it goes back to the judge has a better idea, or a third person's idea, about how long the case is going to be and what the issue is. And it never prevents, our programs never prevent people from having, quote unquote, their day in court.
Sure.
It's our hope that if they don't result in settlement, at least it enables the day in court to be more profitable, productive. Productive is the word I want.
Even that time of conciliation has the feel of that day in court.
Yes,
to, to some of the litigants, correct? I mean,
I would say so. I think by the way, there are many variants of the program. Currently, the one I'm most familiar with is the one in Lowell, Lowell District Court, which I think is pretty much like the one that's in Superior Court in Lowell.
Now, Lowell District Court, is that just starting out, or has that been in place for a while?
It's been in place for about 3 years.
Okay.
And now, I should say the one that's there now, sometimes we've had programs and they then cease. And part of it is because the Lowell program depends a lot on the Greater Lowell Bar Association for its mechanism. The court doesn't have the ability to coordinate volunteer lawyers to come. So the Greater Lowell Bar Association, essentially Mike Najar, works to organizing the attorneys from the Greater Lowell Bar to serve as the conciliators.
All pro bono.
All pro bono. And then we do work, I want to again thank the Middlesex Community College Law Center, because they also are our coordinators too in terms of keeping records, because, we could get onto this topic of what the Massachusetts dispute resolution of the trial court requires. And a lot of this is so things don't get done in a way that isn't appropriate. But,
Sure.
So that's, I don't know how we got on that topic, but in any event, it's the Lowell Bar that coordinates it and makes it happen in the Lowell District Court. And so there were some programs in the past, but because of the lack of the coordination, some of them have fallen by the wayside. But in Lowell, we have noticed, I was there until June, that it really helped us because, as you probably know, Mr. Lilly, I know you practice a lot, that
Sure.
a civil trial day for a jury trial is a treasured date because of the court calendar.
Absolutely.
So what we have discovered with the conciliation in Lowell is that when the trials, it's available to do a civil jury trial, the case is all ready to go.
And so how does conciliation assist in that regard to bring the case forward? Let's say we talked about the two roles of conciliation. One, trying to get to that settlement, but also, secondly, bringing forward the case to be ready for trial, and how that comes forward from the point of view of the conciliator, the attorney who is now has two other attorneys in front of him or her, and is then able to direct that case as far as what should happen next.
Well, I think the way it happens is the conciliation usually occurs when the parties say, we're all ready. We know everything about our case and what we can know about the other side of the case because through discovery. And so it's almost ready for trial. So when they go to conciliation, it's at a point where all the issues are ripe for decision or discussion. I think the other thing that happens in conciliation, the way it's conducted, is we recommend that they have their client, the attorney have their client with them. And of course, if they're not represented, they're there with themselves. But
Sure.
So they hear a third party's appraisal of the case. And again, oftentimes it's not done with both sides there, so the other guy can say, oh, see, he says I'm going to win. The conciliator will say to one side, gee, you know,
Sure.
you, and I think that's helpful to individuals sort of doing a check on whether their case is as strong as they thought it was, and maybe they should think about settling.
So kind of the mechanics of it as far as how the conciliation session is run. The parties and the conciliator first meet together, and then they divide out into other private rooms,
Yeah.
and it's in those private rooms that maybe there's
Yeah.
a little bit more pressure. I don't want to say
I
pressure,
think the conciliator just may say, I mean, yeah, I hear what you're saying, but you know, a jury or a judge could decide differently from the way you see it, or you know, you're bringing in this expert at $5,000, and
Sure.
you know, it may not go as well as you say. I understand they're offering you $3. You know, that's
So there's an evaluation
Yeah,
process
evaluation,
that
excellent,
takes
yeah,
place in
yeah.
with the conciliator that I think differentiates the conciliation from the mediation.
Yeah, I think insofar as, I agree with you. I think in mediation, the mediator may not be so open. I mean, they try to mediate to get to yes, I guess, and usually
Sure.
both parties are there. Sometimes a mediator will have the sides separated, but
A lot of times you don't have an attorney doing it that really knows the court
that's
system.
true too. Yeah, that's true too. Yeah.
And I think the idea behind the conciliation programs, at least from the point of view of the district court, is to have that knowledge of the conciliators actually bring knowledge of the court system and what they might expect to bear for that session. Now, we primarily see conciliation in the Superior Court.
Yes.
We've begun to see it emerging in the District Court first by way of Lowell District
I think
Court.
so. I think around here, some other courts use a mediation variant for their civil dockets. And I can't, Mr. Lilly, speak to exactly how that differs, because I think at the beginning I told you to some people, conciliation and mediation are the same things.
Sure.
But I do think, I understand some courts use, well, I do know in Concord, I believe, Concord District, in their civil list, they use a mediator who could be a neutral. So it's not like conciliation. And the mediator works with the parties to see if they can settle their dispute. And in that court, in Concord, as in Lowell, we have had a program for conciliation for summary process. That's the eviction cases,
Right.
which again, neutrals were not, the mediators were not necessarily attorneys.
Okay. I know in the housing court they do
Yes.
They do have experts or housing specialists that...
Exactly, and they actually work for the trial court.
They do.
And we could go on about how the housing court has some for instance, in Air, some of our towns are part of the Lowell Housing,
Sure.
Northeast Housing Court, some of them are part of the Worcester Housing Court.
That's a whole nother show.
Well, okay, but in any event, but they all could go to housing court, those ones that are part of it, but we found in Lowell that mediators can be of some assistance for those who are in the district court.
What might you envision for Air District Court by way of conciliation services or
Well,
alternative dispute resolution?
I would hope that, we could have a group available to help out parties when we get to a point in a civil matter that, as I say, after all the documents, the depositions, the things have been exchanged, and if it looks like it's going to be a trial, just to give it have a conciliator take a look at it. Our caseload in that regard isn't such where we'd probably have a need for a conciliator all the time. I think I'd like to see it modeled maybe after the Superior Court program in Lowell, which they have a gentleman who I understand, I think is pro bono, who, in other words, Mr. Regan. And the judge senses that this case is ripe and maybe should go to conciliation, and the clerk in Superior Court calls Mr. Reagan, and Mr. Reagan enlists the assistance, again, without fee, of an attorney. I'd like to see something like that, and I think I will work toward identifying maybe somebody in the Northern Middlesex Bar Association to do that. The other thing that's happened in Superior Court, not just in Lowell and other jurisdictions, is the judge has you've had your final pretrial, and the judge has identified, don't you think conciliation, and really alternative dispute resolution.
Mm-hmm.
And sometimes the parties then go out on their own and do it and pay for it privately. As we said at the beginning, there are a lot of programs out there that are private.
Sure.
For not necessarily for profit, but that you pay to do the conciliation.
And meanwhile, the case, while they're out on the privately dealing with this, the case is on hold, so to speak.
Well, this is one thing I like to tell attorneys. It's not going to delay your trial.
Okay.
We do it at the conclusion of all the discovery being exchanged. Everything's all ready to go. But let's see if you can't just do it again and give you a trial date. The issue is sometimes the trial dates are way out there, and you may come for your trial and you don't get reached.
That's
and
right.
that's not the fault. We do our best.
I know. I know.
We do our best.
So we've talked about a number of the hallmarks of these alternative dispute resolutions, mediations, conciliations, the idea of neutrals, of the voluntariness of it. Perhaps we could talk about the confidentiality that's associated with mediation or particularly conciliation. So there's a component of confidentiality that deals with confidentiality as against third parties, as to third parties, but also confidentiality within these private sessions. Could you
Well, I think
speak
I
up to
know.
that?
I think I just happen to know. I think you recently attended a training on conciliation, and a lot of the confidentiality rules are the same, and that's why we require for the court programs that people be certified. They go through 8 hours of training and other training, and also have the experience as a lawyer. And they set forth pretty ways of how you proceed, and you inform the parties of the confidentiality.
I'm sorry.
Yeah, but you may know, it's very clear, it's an obligation that it's confidential. Anything you've said to me, I can't be, the neutral, the mediator, conciliator can't be called as a witness. So,
in fact, and I think for mediators, there is a statute that protects that. With respect to conciliators, maybe less so. But what is being put in place is these contracts that say, if there's an issue, I cannot as a conciliator be compelled to come in and testify to what was said to me in any of this conciliation session. And that's really an important aspect, because it allows the people the ability to bare their soul, so to speak, and really talk about what they want and what they want to see, and not have that come back against them in a trial down the road.
So the rules are, and then of course we, as an attorney, we have our other our rules of confidentiality, and they apply too. So yeah, and that's the importance of being sure you have somebody who does conciliation. In the courts, we make sure of that. That, as I said, we have the Office of Dispute Resolution that was established in 2003, I believe, and by statute, and now is in effect. And the whole purpose was recognizing, in order to make our system of justice more fruitful and effective for people, we needed to set up these or enable these programs to happen, and to ensure that they're done in a way that people's rights are protected.
Sure, absolutely. So, and the other, I guess, other component with respect to the confidentiality is within these private sessions, where if a mediator speaks with a litigant one-on-one, that mediator, unless they've been given the permission from that party to provide information to the other side, that is also remain confidential.
Yes.
The final factor, I guess, that I think carries with it term that is of importance here is the term self-determination. And I think that is really kind of the hallmark of these alternative dispute resolutions, is rather than turning over everything, and again, this is mostly mediation and conciliation, rather than turning over your fate, or the fate of this dispute, to somebody in either to a jury or to a judge to make the decision, that person has the ability to make that decision with the help and encouragement of the conciliator.
I think that's an excellent point. And the only other thing I'd like to add to that too is closure.
Closure.
I mean,
it is an excellent tool for closure.
But I think the self-determination is very important. And that's why I think we would require that at all possible for the parties, if they're represented by counsel, to have their clients there.
Sure.
Because the self-determination
Absolutely.
requires that they
You need to be
sort of
present.
Yeah,
in
need
order
to be present.
in order to make it happen.
In some cases, it's not going to happen. A lot of the things that we have in the district court with credit card, debt, things of that nature. But I do think it does help, usually the defendant who's being sued for credit card debt, to have some ability to have access to this.
Well, unfortunately, that brings us to the end of our program.
Oh my gosh, I can't believe
I think we could go on for quite some time. But Judge Kremens, I thank you for joining us. This has been a presentation of Legalese. I would ask you to urge you to use local counsel in any decision making that you have. And I thank you for joining us.
Thank you. Wow, that went quick.
Yeah.